Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our bi-weekly community conference call where we try to answer your questions as best as we can in the time that we have. You have heard the disclaimers as you logged into the call. Those disclaimers apply. I have marked certain questions as frequently asked questions. First, I want to deal with them. And if you have any follow-ups on each one of those frequently asked questions, please go ahead and ask. After that, I'll deal with the other posted questions in the order that they are posted in. And if you have any follow-up questions on the posted questions, you can ask at the relevant place. I don't think I'll have time for new questions, but I'll try. So unless you have posted your question, I may not be able to get to it. Thank you all for being here. Let's begin with the first one. This is a very commonly asked question. Do I have to carry my green card with me at all times? And can I carry a copy? Can I carry a notarized copy? What if I lose my green card? All these things are very genuine concerns. But in Trump's America, I would rather not take a chance. If you look at Section 264 of Immigration and Nationality Act, which is codified as 8 USC Section 1304. Subsection E very clearly says, every alien 18 years of age and over shall at all times carry with him and have in his personal possession any certificate of alien registration or alien registration receipt card issued to him pursuant to subsection D. And the subsection D is about green cards and other registration, etc. Any alien who fails to comply with the provision, so if you don't carry your green card with you, you are guilty of a misdemeanor, which means a crime, and shall upon conviction for each offense be fined not to exceed $100 or be imprisoned not more than 30 days or both. So they can actually put you in prison for 30 days. And I don't see any substitution. You have to carry your green card with you. Have I seen anybody getting into trouble for not carrying their original green card? No, but I have not seen anybody like Trump be president also. So I would strongly advise, if you are a green card holder, please carry your green card with you. Do we have to do police complaint if green card is lost? Normally, no, but I think it's a good way to go because it creates a paper record, and it would probably help you if you carry that police report instead of the green card while your replacement green card is applied for. I think that's a good ground for not having any issues. So what is the procedure for filing a police complaint? It depends. Where I live in Arlington, Virginia, I can do it online. Arlington County has an online complaint system. You can pick up the phone and call. You can go by the police. Don't call 911. Call non-emergency number of the police. Tell them you want to report loss of documents. They're not going to investigate, but they'll give you a report. Carrying that copy of report would be good for you. Okay. Please feel free to ask any follow-up questions on this issue. No new questions. Press *5 on your phone if you have a follow-up question. *5 on your phone. Okay. There are no follow-up questions. I'll go on to the next question. This one is a little more complicated. I'm not sure how much of it I can cover. It talks about H-1B and green card transfer from a non-profit to a for-profit, advantages, disadvantages, problems. So questions on green card filing and H-1B processing through a non-profit organization to a for-profit. I'm currently working for a non-profit on a cap-exempt H-1B. They've started my green card. Is the green card any different for both? And the answer is no. There is no advantage in going through for-profit or non-profit. That's just irrelevant. 2. Can my I-140 from a non-profit be transferred? No, non-profit or for-profit doesn't matter. You cannot transfer I-140s. You can transfer priority dates. Unless your I-140 is based upon a national interest waiver or an EB-1A, you cannot really transfer your I-140s. The only time you can transfer your green card. And the green card can be transferred once your I-140 is approved and 485 has been pending 180 days. Then it doesn't matter what the nature of the organization is. So let's say you are working as a database administrator for a nonprofit and your green card is filed, I-140 approved, 485 pending 180 days. You can transfer that green card to a for-profit, state government, federal government, any organization, as long as your job is database administrator or the next higher promotion. For example, let's say chief data architect or something like that. Okay. What are the possible ways that I could move to work for a for-profit organization? From your previous calls and through my research, I found the following ways. First is finding a non-profit employer to file my CAP subject H1. Can I start working for them as soon as the H1 is picked up in the lottery? Let me think about this for a moment. I don't think there's any specific law on this issue. Technically, you can start working for them on receipt, but obviously you will only get a receipt if your case is picked up for lottery. So if you have been maintaining H1B status, I believe you can start working for a CAP subject employer as soon as your H1 is picked up. If a new employer sponsors my CAP subject H1 and I don't move to the new employer, will my current CAP exempt H1 be still active? Absolutely. Should I have to go under CAP next time I file a CAP subject? That's a tricky question to answer. I'm not sure I can give you a complete answer to that question. I can give you a guess. If your H1B CAP subject H1B is approved and it is not revoked till October 1st, I don't think you will be subject to a CAP to work for a for-profit in the future. But if it is revoked, also one more thing, it shouldn't be revoked before October 1st and you should receive your change of employer. So in other words, you should get a new I-94 with the case. Because USCIS has been taking this position that just getting an H-1B approval does not put you over the top where you are safe from CAP quota issues. They say unless you receive a change of status or go get a visa stamping, till that time you are not exempt from the quota. So you must not only get an approval, you must also receive an I-94, which is a transfer of employer. But you can still continue working with the old employer. Another way is applying for concurrent H-1B. Yes, that's a strange provision in the law where if you have a quota exempt H-1B, as long as you maintain that without worrying about the quota, you can also work on a concurrent H-1B for a quota employer. Moving to H-4 EAD, not a good idea because in June they are going to announce the revocation of the H-4 EAD regulations. That's what they said in court. Joining a master's CPT and filing a CAP, yes, that's definitely an option. Star 5, if you have a follow-up question on this, star 5. Okay, let's go on to the next question. I think this is the one that we just did. Yeah, that's the one we just did. Okay, then there is another one. Let's go to the frequently asked questions first. Another frequently asked question in the EB5 investor green card through investment area. Is it possible to use a promissory note secured by property in a foreign country, like in India? And the answer is yes, it is possible. The only problem is, I don't remember the exact laws on the duration of the promissory note. I don't think you can delay it all the way to 2 years. I think probably will have to be a relatively shorter period of time, but I don't remember the time. But I do remember we did a case in which there was property in India based upon which we had given a promissory note in USA. But to make that work, this investment was, let's say, in Alabama. So first we had to get a promissory note made in India. Then we had to show it to the lawyer in Alabama to make sure that it was acceptable and legal, that kind of note with that kind of language under Alabama law. Then we had to get a legal opinion both from the Indian lawyer and from the Alabamian lawyer to attach with our promissory note that this promissory note was legal under the laws of both the countries. So it's a little complicated, but it can be done. *5 if you have a follow-up question. *5. Okay. We'll go on to the next frequently asked question. This is also very commonly asked. At what stage should I join my future green card employer? So future employer is planning to file my green card PERM in the month of May. I have a PERM with the current employer also. Is it advisable to join the future employer before filing the PERM? I'll tell you why that is a better idea as far as only one aspect of the case is concerned, which is ability to pay wages. So when your employer starts your green card, from that date forward, they must show that their tax returns have enough money to pay you. If you're already working for the future employer when we file the PERM, you have an easier time proving that because you're already getting paid some salary. The problem is, let me rephrase that. If on the other hand, the employer has a very healthy tax return, only their lawyers can tell them, then it doesn't matter when you join them. So if we are worried about the ability to pay wages, it's better to join before filing the PERM. If the tax returns are extremely healthy, then you can join at any stage you like, either before or after approval of the green card. I-140 approval can be affected because of the ability to pay wages, but if the ability to pay wages is strong, you can join a future employer anytime before or soon after the approval of the green card. *5 if you have a follow-up question on this, please. *5 on your phone. Okay. So this is another one that comes up quite frequently. I am on H1, the child is turning 21. What will happen? Normally, the children of people undergoing green card process convert to student visa if they are in school. If he gets covered by the CSPA Child Status Protection Act, even though he has a student visa, it doesn't change his green card status through you. And again, if he goes to India for a degree for 4 to 5 years, will the green card processing still stay valid? And the answer is yes. But there are some technical details you have to attend to, but that is certainly possible as long as he's not got a problem with aging out. He's covered by CSPA. You have no issues. *5 if you have a follow-up question on this. *5. Okay. Let's go on to, I guess that's all the frequently asked questions we have. Now let's go over the other questions. So this was a frequently asked question. This was a frequently asked question. This we did already. Now, Thankful user says, we have a special needs dependent and we got our compelling reason EAD. If the dependent on EAD ages out after 21, can they still apply for renewal of his EAD? My guess, I haven't reviewed the regulations with this in mind, my guess is no. Because normally in order for somebody to be eligible for benefits under you as a child, they have to be under 21. You don't have to go outside. Yeah, I guess they have to. If they were on compelling circumstances, EAD, the only way to get back into status is to go outside and come with a visa stamping. I want to remain in the USA, and since my special needs children may or may not get a green card before he turns 21, can I look for any other option like EB-1C while being in the USA? See, EB-1A can be done within USA, EB-1B can be done within USA, but EB-1C, which is International Manager, requires you to be outside USA for at least 1 year out of the last 3 when you apply for your green card, and you must have been working for a branch or a subsidiary of the American company. So if you worked for IBM India for 1 year and IBM USA wants to process your EB-1C green card, they can. You have to be physically outside USA. Are there any options for parents with disabled children? No, there's nothing special for them. Okay, I see there's a follow-up question. I don't know to what, but let's see if we can get to that. I'm done with this question also. If you have any follow-ups, press *5. Let's see who the follow-up question is from. This is from Michigan. So Michigan, go ahead, please. I can hear you. Hello, Michigan. Hello. Area code 810. I can hear you. Okay, I don't know what's going on. All right. So we're done with this question. Next question is a little too complicated for me to answer. Really won't be able to help you much. IND 2121. There's a fraud finding in your case, and first of all, is your waiver going to be retroactive? These are very intricate questions of law. I have to actually read them. Okay. Michigan, go ahead, Michigan.
Raju ji, can you hear me?
I can hear you fine. Yes, sir. Go ahead.
I couldn't hear you.
I can hear you. Hello? Hello?
Hello?
I can hear you. Hello? Hang on 1 second.
The conference is now in conversation mode.
Can everyone hear me, guys?
Raju
Can everyone hear me?
Yeah, can you hear me?
Yeah, I can hear everyone.
Yeah, I can hear now.
Okay, I'm gonna put you back on
Okay, so
presentation mode.
thank you for this. The conference is now in presentation mode.
No, I've just put everybody on mute, guys. I was just checking if people can hear me. Let's try one more time. Michigan, go ahead. Michigan. Yeah, Michigan.
Hello?
Yeah, I can hear you fine, sir. Okay, something is wrong with the phones. Not much I can do about it. I can hear.
Hello?
Yeah, I can hear you fine. Hello. Okay. Done here. So when you have a marriage fraud charges and they are substantiated, not only do you have a problem with immigration, you could have a problem in, of course, naturalization, your green card, and even criminal issues, because marriage fraud type of issues can be taken over to, I think it's a felony, 5 years in prison, something like that. And yes, if you have those kinds of issues, you could have a lot of problems down the road. So it's a little difficult for me to give you an abstract answer. These are very specific issues. Won't be able to help you much. Generically, I can tell you only this much. Okay, Michigan, let's try one more time. Can you hear me?
Hi. Sorry if I'm bothering. I couldn't hear Rajiv ji talking.
Yeah, I can hear you. Can you hear me? Hello? I don't know what's going on. Everybody else can hear me. Alrighty, we're done. Let's move on to the next question. This is from Dave regarding AOS versus counselor in AC 21. I'm from India, self-petition DB2NIW, I-140 approved based on research category. Wife is from Malaysia. She's got an EP2 I-140 approved. She's got a J1 physician waiver until August 2018. So she's on H1B right now. What will be the best and the quickest way to get a green card? You do realize that you can apply through multiple categories. So, of course, she cannot apply for an adjustment of status until her 3 years of H1B waiver are over. But as soon as you can apply for your own 485, and when she becomes eligible, you can file with her as well. Can I do AOS once she completes waiver and wife do consular processing in Malaysia? You can definitely do an AOS, and she would have two choices. She can file her own AOS, or she can file as following to join through your AOS when she finishes her home residency requirement waiver. Is it allowed to do AOS and counselor process at the same time? I don't think that's going to make things any faster. And I don't think counselor processing is going to be any faster than the AOS. You certainly can't do both. You can go to a certain distance trying to do both. At some point, they'll make you pick one over the other. My wife would like to switch jobs. Do we have to stay for the same employer who did I-140 after green card approval for some time? I have covered that issue at great length in several frequently asked questions. If you just go take a look at the frequently asked questions, the short answer is that as long as you have the intention to stay with them indefinitely, later on if you change your mind, that's okay. But the date of approval of the green card should carry that intention from you. *5 if you have a follow-up question. I'm going to try Michigan one more time. *5 if you have a follow-up question. Yeah, Michigan, try again, please. Michigan. Hello? Michigan? For some odd reason, let me try unmuting you manually. Can you hear me, Michigan? Can you hear me? I don't know what's going on. Okay. Well, I have the recording so you folks can listen in the recording. That's going fine. I can tell from the way the sound bar is moving. Let's go on to the next one. This is about tax returns. So they want to go back and amend their tax returns to reflect married in tax filings. Marital status was reflected as single because wife was still in India and had never been to the US before. It was suggested that you should amend your tax returns. You were married in August 2014. As long as there is no other complication, there is no misrepresentation anywhere, I don't see any problem with going back and amending your tax returns. The only thing I care about from the immigration perspective is that there should be no misrepresentation in any paperwork. So as long as there's no misrepresentation, I don't see any issue. *5 if you have a follow-up question on this. Okay. So here is a question about ACICS accreditation, which was restored what do we do with the STEM extensions for people? And I think your International Students Office has told you the right thing to do, which is a little bit further down. Somebody else said the same thing. The best approach for these kind of issues is to go back to your International Students Office and see what they can find out from the USCIS, what they are recommending. Of course, you always have the option of getting all together and filing a class action lawsuit against the USCIS, or even an individual lawsuit against the USCIS, but that can take time and money. Of course, time can be shortened if we are able to show to the court that there is some immediate relief needed. And normally what happens is when you file a lawsuit, that gets the government's attention very quickly, and often these lawsuits are settled. Okay. Star 5 if you have a follow-up question on this. Star 5. So my advice would be to start with the International Students Office. Next question is a little long and complicated. Not sure what exactly is going on. PERM to be filed 2018. PERM to be approved 19. I-140 to be approved 19. Recap available for 30 days. If I apply for normal processing of H-1B, it takes 5 months. So wait for the I-140. These are too many facts for me to keep straight. H-1B extension RFE to be responded by April 30th. The I-140 can we work after? Hang on one second. I think I kind of understand what you're saying. If you have only 30 days recap coming and you file for an H-1B extension, you can't continue working past those 30 days, even though technically under the law you could. So if the maximum amount of time coming is 30 days and the law says you can work while an extension is pending, you can't work beyond 30 days because that's not coming to you. And you cannot change your request from 30 days to 3 years while the case is pending. I don't think the government will allow that, because whatever your facts are, whatever the laws in your favor are, on the date you file the application, you are locked into that. While the case is pending, if the I-140 is approved, unless the government has changed their view drastically, I don't think they'll accept it. I don't see any options for ensuring a break in the job, ensuring no break in the job. And the H-4 EAD itself is a little dicey, because as you folks know that in June they might start the proceedings to take it away. How long it would take, I don't know. But definitely this is not something that you can bank upon as a long-term strategy. Star 5 if you have a follow-up question. Star 5. Okay. So somebody wants to visit Cancun using what is called automatic visa revalidation. Automatic visa revalidation says if your visa has expired, but you have a valid I-94, you can travel to a contiguous territory like Canada or Mexico, as long as your trip is less than 30 days and as long as you don't apply for a visa while you are there. So should you be traveling right now on an H-1B? Well, that is something you should discuss with your lawyers who process the H-1B. Theoretically, there's nothing wrong with it. But if your H-1B has things that you're not clear about, for example, if you are working in a location without an amendment, that can happen sometimes, or you are working at a third-party site, if you're working in-house, getting paid, completely approved, everything is in order, normally I wouldn't have a problem with traveling, but it is something you should discuss with your lawyers. They can tell you better. Okay. I can't give you a generic answer. Star 5 if you have a follow-up question, guys. Okay. Let's go on to the next question. So this one is H-1B transfer before October 1st. I'm working for a company A on cap exempt H1, company B filed a cap subject H1. And if suppose this new cap subject H1 gets approved, can I transfer this approved H1 to company C before October 1st? And the answer is yes, and there's no time limit. But you have to make sure that company B, which filed the cap subject H1, doesn't revoke your H1 before October 1st. I'm not sure what the government's current thinking on this is. I don't remember off the top of my head. But they used to say if your cap subject H1B is approved without change of status or it is revoked before October 1st, you may not be able to transfer it. But I don't remember the exact details. I have to look at the law. So don't take my word for it, but there's definitely an issue here that needs to be examined. If the new cap subject H1 got approved, and if I chose not to move and stay back, do I have to go to the lottery again? I answered that question earlier. So if you just review my answers a little bit further up in the first 3-4 questions, you have all the answers. Next one is just a question. I'm completing 5 years of my green card in the next couple of months, and I'll be applying for citizenship. And there's a child with a developmental disability since birth, also enrolled in a state university for bachelor's, but somehow managing to pass most courses. If we do not apply for a waiver of English and civics, can we apply for a waiver later? You can always refile for naturalization as many times as you want to, and if there is a reason for a waiver, it can be filed in a subsequent case, yes. And I don't think just because somebody applied for a waiver from English and civics test, they become a question of liability for the state or state charge. So no, I wouldn't worry about that. *5 if you have a follow-up question. Either something is not working in the system today or people don't have questions. Next question is Rutun Patel. My OPT STEM extension got denied. Same, yeah, I discussed this issue just a moment ago. The ACICS or whatever that is called, ACICS. You should start by having your International Students Office talk with the USCIS. See what USCIS says on these cases. You can, of course, ultimately even file a lawsuit if necessary, a bunch of you together. So another thing you could do is you could contact your congressman's office and ask for their help to get an answer from the USCIS. Normally, a congressman's office can get you answers pretty quickly if the International Students Office won't help. Okay, I'm going to try one more time to see if Michigan can talk to me. Yeah, Michigan, go ahead. Hello. Hello, Michigan. Hello. Okay, still the same problem. All right, so next question is another 6 years of H1B are completed, moved to H4 status, PERM got approved, I-140 got approved, applied for H1B, received specialty occupation, RFE. I'm sending the response by the end of April. Let's see if there's somebody's hand is up. Yeah, Detroit, go ahead. Detroit, Michigan.
Hello,
Yes, sir.
Rajuji.
I can hear you. Hello, I can hear you. I don't know what's going on. Okay, so shall I apply for H4 EAD as a backup option? That's a very difficult decision to make, as you know that the H4 EADs are going away soon. So I can't really say whether that's a good option or not. I don't think it is. Once your I-140 is approved and it stays approved for 180 days, you can actually don't have to worry about the I-140 revocation anymore. Okay, that's not a problem. But if the employer is not going to revoke your I-140, you can get your H-1 transfer with any employer even now. So let's go on to the second last question of the day. I arrived in US in 2012, completing sixth year in May 2018. With recapture, that becomes 1st March 2017. There's a priority date on a PERM application of 20th March 2017. Got an RFE from USCIS on the H-1B extension. H-1B got approved for 2 years. 1 year for 6th year on H-1B, another year for the PERM, with the end date of 1st May 2019. Once they've given you the approval, even if the PERM goes away, I don't see how they can take it away. Okay, so those 2 years should be okay. You got another PERM file, you travel to India for 20 days. You've got an expiry date now of 1st May 2019. Now the second PERM has also been denied, and they're going to appeal. I want to know if I can stay in the US past 6 years. Why, if you got 2 years approval, then I don't see why you cannot stay. And by the way, even when the PERM appeal is pending, you can keep getting H-1B extension. And because like I said, the way I see the law, if on the date you asked for the H-1B extension, you were entitled to it because of the PERM, and then the PERM got denied or revoked, and you already have your extension, I don't think they can take that away. Okay. And the last question is, I have a question about EAD extension. Is the EAD extension required while waiting for I-485? Absolutely. What is the earliest time to apply? 6 months or 120? Neither. 180 days. Okay, guys, I think people are having some trouble in getting through. They can hear me, but I can't hear them, or I can hear them and they can't hear me. So I'm going to put this on conversation mode. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.